And welcome to another episode of PLA with myself and Nick. And today we are joined by one of our good and very familiar faces, Bruce Barkhuizen, who is a senior associate here at Bruno Simao Attorneys. Thank you, Bruce, once again for gracing us.
It's a pleasure. Thank you for having me.
Thank you. Right. So today we've got two questions, and we'll do the first one with yourself, Nick, and then we'll jump into the second one with Bruce. But of course, seeing that Bruce is here, I think we'll invite his comment on both questions regardless. Yeah. So the first question, Nick says that we have an issue with the tenant who moved out on the 4th of Feb. Right. The landlord, the agent, and the tenant went through the property on the 5th of Feb, which is the day after the tenant moved out. The cleaners were still busy on the day of the 5th. We also did an inventory and written inspection with the tenant that afternoon. The tenant, however, had to leave early and did not sign the inspection. The landlord had instituted then a claim. And then the question becomes, the tenant has now appointed an attorney who states that we should have done the inspection within 3 days prior to the lease coming to an end, and therefore the landlord has no claim. How can you do, the question becomes, how can you do an inspection prior to the tenant moving out? He also quoted the amended Act of 2014, which according to the viewers' knowledge is not yet in force. Nick?
So it's actually a really good question. So where this comes from is the Rental Housing Act. Now, the Rental Housing Act has certain provisions which are deemed to be part of lease agreements. One of the provisions in terms of the Rental Housing Act, this is Section 5 F, okay, basically says that what the landlord needs to do is they need to arrange a joint inspection with the tenant 3 days prior to the termination of the lease agreement. Okay, so this is still while the tenant is in occupation premises, before they're planning to move out. The landlord and the tenant are supposed to do a joint inspection of the premises and figure out what needs to be fixed. Now, the question that's been asked by the writer is a very good question. How do you determine what has been damaged or what might need to be fixed 3 days before the tenant vacates the premises? Remember, it's you could have a tenant who's not going to vacate until the very last day of the particular lease agreement, and therefore they've got all of their furniture, they've got everything sitting inside the premises. And it is a difficult question. The fact that the legislation prescribed it in that particular way has caused a lot of our clients problems. Well, I'll speak from my perspective, a lot of my clients' problems, because it can be very difficult to assess damage or what's happened on the premises if your tenant has a bunch of things inside the premises which could hide, a wall that needs to be painted or something that's been broken, a carpet over tiles. I mean, unless you are literally shifting the entire property around, very difficult to do. So what practically happens is sort of what's happened in this particular perspective is often what my clients will do is they'll go do a joint inspection after the tenant has moved out. Practically, does that sit well in terms of the Act? No, not really. The Act requires it to happen 3 days before, but most people have good relations when they're vacating, and these things are done just outside of the Act like that, and that's absolutely fine. What's interesting here is the tenant has taken a different approach. So that joint inspection didn't happen. They decided to do the joint inspection after the termination of the lease agreement, as is pretty normal practice. But now the tenants decided to go get an attorney to try and escape any sort of liability, and they didn't sign the exit inspection form. So what do? So luckily, there is a provision within the Act that's going to help us in the circumstances. So yes, absolutely, the Act says you are supposed to do a joint inspection between parties 3 days before. But what the Act then says later on is if the landlord can't get the tenant to do that joint inspection 3 days before the termination of the lease agreement, the landlord is entitled to go ahead and do the inspection on their own within a period of 7 days of the termination of the lease agreement. Now, our writer is very lucky in this regard because they say that they did it. The termination would have been on the end of January, and they say they went on the 5th of Feb to go do this inspection. So inadvertently, without knowing it, they've actually complied with the provisions of the Act. They've gone within a period of 7 days and actually done the inspection. And the fact that the tenant hasn't signed in this particular case actually doesn't worry me, because Act envisages a circumstance where the tenant wasn't going to be there in any event to do the joint inspection. The landlord was entitled to do the inspection in the tenant's absence. Okay, so in respect to the response from the attorney is being absolutely correct. The inspection was supposed to happen 3 days prior to the lapse of the lease agreement. But what the attorney is not going to tell you, because he represents the tenant, is that there is another provision saying that if that didn't happen, the landlord is entitled to go and do the inspection 7 days after. And my submission is that the landlord has done that in the circumstances. So while the attorney is going to say yes, he's obviously going to represent his clients and say you don't have a claim. I don't think he's being very fortuitous with the way it works and correct in the circumstances. I would submit to the landlord, you are perfectly entitled. You still possess a claim. How are you going to do that? Are you going to go through, perhaps the rental housing tribunals, the best way of doing that? We don't know what the extent of your damages are in the circumstances, but I certainly, if I were you, writer, I wouldn't leave it at that point. I wouldn't simply, say, oh well, I've lost out. I still think there's a sufficient ability for you to claim. I still think you sufficiently fall with the act, regardless of the non-signature by the tenant, regardless, of the fact that it was after the circumstances. And in any event, if you approach the tribunal and say, look, we did agree to a joint inspection, it just didn't happen to be within the 3 days. The tribunal's not silly about these things. They're there to mediate disputes and try come to a resolution. So I think you're going to find favor in that circumstance, rather than the strict approach which the attorney for the tenant has now tried to proffer in the circumstances. So absolutely go for it. And in respect to the amendment, you put a little note there on the amendment. Look, the amendment for me is no concern. It doesn't change the provisions that I've mentioned in terms of Section 5 in any way. It didn't affect those, so don't worry about it. Those provisions still apply. And I would submit, seek an attorney for yourself, call one of our officers. Alternatively, depending on what your quantum is, you might not want to get in touch with an attorney just because the costs are not going to be sufficiently, a value that's going to justify it. Then approach the rental housing tribunal. They really do good work and can help.
Yeah. So thank you very much there, Nick. And of course, Bruce, you are here today. So we will obviously have to invite you for an additional comment there, please.
Well, truth be told, I'm struggling to think of something I could possibly add to Nick's answer, as it touched on all the most important aspects. Something I'd like to mention is that the landlord actually here did was trying to substantively comply with the act. So I do not foresee this technical argument being a bar or hindrance to the landlord's claim for damages. I mean, the landlord has tried. The tenant even appeared on the day for an inspection. There's no obligation to sign any document in respect to the inspection. So I think, as Nick put it, it's done and dusted. Landlord ought to be successful. I don't think, in particular, I think that the magistrates' courts would side with the landlord more than they would side with the tenant.
Right. So there you have it. Thank you very much, gentlemen, for the answer to that question. And I really do believe that the viewer then has quite a